Hey guys, it's Shawn. I'm with you today. I'm going to spend some time today helping to inform you about NDAs, non-disclosure agreements, which are very prevalent in the business world. They are almost, ubiquitous. They are something that you expect to see regularly. But they have a lot of issues with them that few people talk about, right? Most people act like an NDA is some type of magic solution. By getting an NDA signed that you are protected, that there aren't other ways to protect confidential information, that there aren't smarter strategies, and that there aren't other things to consider around NDAs. And in fact, a lot of people view NDAs as being a boilerplate standard item. I will tell you there's not. They're not. There are different forms of NDAs out there. Different people use them for different ways. And they have variances in them. So today, we're going to bring you up to speed on NDAs, what they're not telling you about NDAs, some of the pitfalls, and some of the things to consider as you're using them in your business. This will make you a more sophisticated business owner, a more sophisticated user, and hopefully lead to better negotiations, better outcomes, and then protecting those very important business secrets that you have. There's trade secrets, there's things that you actually want to protect with the NDA. By understanding the NDA and the NDA process better, you'll be better positioned to go out and protect yourself, your business, and the long-term longevity of it. So we'll jump into it here. As always, we're talking about some legal issues today. This is not legal advice. I'm just giving you information, education, entertainment. These are things that you can take to your lawyer and consult with them about what's appropriate for your situation. So, many NDAs sound good, and they also sound scary, right? That is really usually the jumping off point. People think that this is great. I'm going to have this other person sign an NDA. They're not going to be able to disclose my information. It's going to scare them into not doing something because it's going to have clauses about how I'm going to sue them if they use my confidential information against my will. And, I'm sure they'll go back and protect my information. That's great. The problem is, of course, there's a step beyond just getting the other person excited or upset. Is you've got to actually make this thing enforceable and usable, right? And so a lot of NDAs sound good, but they don't have the mechanisms to carry them out. And maybe they're not properly tailored to the nature of the confidential information. Meaning to say, just sending somebody an NDA, just having a signed NDA returned to you, doesn't necessarily mean your confidential information is protected. And it doesn't mean you're not going to have problems down the line. They really have limits on what they can do, right? They only protect the scope of confidential information set forth therein. So definitions are important. Setting those scopes are important. Making sure that the right things are covered is important. Not covering too much can be important, right? I had a client recently that wanted to do an NDA, but they still wanted to let the person who was signing the NDA still go out and potentially, talk to potential customers and other people, right? So now you've got to now carve out of the NDA some of this downstream use, right? I'm going to tell you, company is going to tell, NDA recipient one an issue, and they're going to discuss confidential information, but then they want that NDA recipient one to be able to tell that to person two so that they can create sales or they can engage in transactions, right? So we don't necessarily want to cut off the user from all uses of the information. They may have appropriate uses. Maybe you're hiring a supplier, and then that supplier then has to do certain things to create the goods or services that they're providing to you. They've got to then have downstream uses, right? So there's limits, and they need to be customized and tailored and carved back to your situation. So there's real limits on what they can do. They're not just going to stop all disclosures of information, and they certainly don't protect against, what could happen in the event of, a third-party breach, an accidental disclosure. I mean, they may assign liability for those things. They may allocate risk for those things. but they don't necessarily handle the issue of now what, right? We still got a problem. If I give, business one gives confidential information to an NDA recipient, that NDA recipient goes and blabs it to everybody. Well, they may have broke the contract, but me as the company, I still have all my confidential information out in the world, right? Everybody's seeing it. So it has real limits on what it can do. And enforceability is a real issue. This is particularly important if it's big company, small, recipient of information, right? So big company, you're the bigger company, you're giving your information to an individual or a small company. What if they do disclose your information? What if they completely botch the NDA? What do you do now? You can drag them to court. You can sue them, get a judgment. You might be able to get an injunction that they can't keep telling people. But again, your confidential information is already gone, right? They've told everybody. How do you get the genie back in the bottle? And then even if you win and win big, you get a big number, they owe you a bunch of money because they really hurt your business. If they ain't got that money, where's the money come from, right? Now you got a loss, maybe a partial recovery if you're lucky. But you still have all your confidential information out there, right? And you were lulled into a sense of security because you said, oh, we got an NDA. They can't tell our information. No, they can tell your information. They legally have broke the contract. They've done what they shouldn't have done. They can still do it. It's just they physically it can be done. They shouldn't be doing it, right? They should be complying with their contract. But they can actually do it, right? I mean, there's people who do things every day that breach contracts. In fact, there's a theory out there in the legal world called efficient breach. The idea being sometimes contracts should be broken. You agree to sell something to one person, for too low of a price. Somebody offers you a higher price. You go with the higher price person. You break the contract with the lower price person. That's terrible. But then if you can cover their damages and do business with the higher price person, and you win, they win because they get their damages covered, and you might be in a situation where a breach is actually better for the world, better for the economy, and you just pay off the expenses of what it costs to clean up the mess made, right? That is a theory, and that does make sense in some cases. We've got to weigh that, but there's inefficiencies too because it can be disproportional. Again, your information's out there. You're not getting the genie back in the bottle. Maybe you win the case. Maybe you were right. Maybe you did the right thing in their contract. They did the wrong thing, but you still got a big loss. So that enforceability, the ability to carry it out, is a real issue. And it's not appropriate in all cases. A lot of people will run around, ask for an NDA from everybody, right? Everybody they encounter. You see this a lot in the technology world. People ask for an NDA, and then, as some people point out, you get an NDA. Some people won't sign them. Big investors, people that have money, often won't sign an NDA. They'll just say, hey, talk to me. Maybe they'll sign an NDA further down in negotiations. But if you want to have that kind of initial opening discussion and kind of get the process started, show them enough about your company to get them interested, they're not going to sign an NDA. And for practical reasons, because what'll happen for a lot of investors or a lot of people that are active in the business world is you may have 4, 5, 6 people come to you with the same idea over time, particularly within an industry, right? And now if you start signing NDAs with all of them, person 1 tells you something, person 2 tells you something, person 3 tells you something, person 4 tells you something. You've essentially gotten the same information, let's say, from all 4 of them, but each of them thinks that they gave you the confidential information. They think that they're protected, but maybe they're not, right? You've got the same information from 4 people. And usually there's a clause in a well-written NDA that talks about information that was already known or already publicly available, which kind of then starts the process of what does your NDA really say? Does it really work? Is it enforceable? But they don't always work in every case, right? Sophisticated, large investors with a lot of money to put into the market, they're often just going to reject these things and say, I'm not signing them. I've had people come to me, want to tell me something about something super secret. They're like, sign my NDA before you tell me about it. And I'm like, I'm not going to sign an NDA when you haven't even told me what you're going to tell me about under the NDA, particularly because, it may cause a conflict, right? I may already know things about what you're about to tell me. I'm not really violating your NDA. I'm not taking information from you, but you might later perceive that, right? Because I already knew it. You didn't know that I knew it. I signed an NDA saying, I'm going to keep the information confidential. You tell me something I already know, and then we have a factual issue. Factual issue means judge or jury trial, usually in a legal litigation context. Factual issue that's open, and then we've got to fight over the facts, right? We've got to develop witnesses. We've got to do depositions. We've got to figure out what the facts are, look at emails and all this. Very costly and expensive, right? So, you're not always going to want an NDA, or at least the other person on the other side, the recipient of the information, isn't always going to want to bind themselves legally to it. And again, people with negotiating leverage know this issue. They're well aware, and they often don't want to get involved. Which means, NDAs have a time in the negotiation process. Where do they fit into that overall deal? Do they come early? Do they come late? Is there a Goldilocks time that's just right? And can they be part of a broader contract, right? I just recently read a piece from another lawyer, and that's their recommendation, right? You make this part of a broader contract. You don't necessarily have a separate standalone NDA. You get to a certain part of the deal, you sign a broader agreement about the deal, and you include confidentiality provisions in there. That's certainly an approach. I find that, again, dealing with investors a lot on behalf of my clients as they're growing and they're trying to bring in capital and get that phase of their business going. These people, the people on the other side, the people with the money that are potentially looking at deals, they're looking at lots of deals. They don't want to sign a lot of NDAs and get into potential litigation about sharing information among these potential deals they're looking at. If you want access to their money and you want a chance to step up to the plate and potentially get an investment, the deal is give me your information. I'm not signing an NDA, right? And that can be negotiated back and forth. Depends on the relative leverage of the people, their sophistication, success rates, whether it's possibly an NDA in or not, right? But, from a recipient of information standpoint that has a lot of people buying for their time, why do I want to get into this process? Why do I want to put myself in a situation where I could get sued later and this thing could be waived in front of me? When I can just move on to something else, right? So there's a lot of negotiation involved in whether an NDA is even appropriate. And too many companies think, oh, well, I'll just get NDAs on everything. It really isn't that simple, always. A lot of issues there. Again, the information you get is probably simplistic. Legal matters tend to be complex. They have a lot of issues with them, right? And you've got to sort it out for yourself. And so this is to say NDAs are a tool. They certainly belong in your tool chest. Every company probably needs a good NDA tailored to the information that they have, their industry, how that information is being disclosed. So it's good to have an NDA on your shelf. Probably want to have it ready in case you do end up in a deep discussion faster than you thought. But they're not an end-all be-all. And they have a lot of issues, and they're not appropriate in all cases, right? So that's what this video is about, is really getting us off of thinking that NDAs are just automatic, reflexive, and wonderful. They are a tool in the tool chest, along with many other tools that may or may not be appropriate. Your lawyer should hopefully walk you through that, figure out what tools you should be using when, how to build what you want to build. If you have comments, drop them below. I love hearing from folks, what issues you're dealing with, what your thoughts are on NDAs. I'd also love to hear any other business law, business issue topics you'd like covered in future videos. All right, folks, Shawn signing off. Looking forward to reading your comments and chatting with you down there. Talk